Honorable members, good morning and welcome. And colleagues from the Road Accident Fund, good morning and welcome as well. And thank you very much for being here. And our other colleagues from the AG, journalists, members of the public, good morning and thank you very much for being here today. I'm just going to set a bit of a context. I think it's important for members of the public, but also our guests from the Road Accident Fund to get a context to this process that we on, so that we can be of assistance as much as possible in this process. This is enhanced oversight. I think when people hear the word inquiry, they sometimes think somebody will be found guilty of something at the end of it. One of the things, one of the objectives the committee set itself is to also look at systemic problems. It's one of the points of our relationship with the SIU, for instance. It's something the Auditor General looks at all the time. In other words, it's not always individuals that are a problem. It doesn't mean that there aren't cases like that, but sometimes the system is broken or obsolete in one or other ways. And the committee's responsibility is to make those observations, base them on evidence, write its report, oversight report, and then table it before the National Assembly. That becomes the basis for continued oversight by Parliament, this committee as well as other committees. So at the end of this process, there is likely to be recommendations for the Transport Portfolio Committee, for instance, and their members may come and participate in this process. And you may see that they will indeed do so. There will be recommendations for the ministry and how it oversees the institution. There will also be recommendations for the Auditor General, etc., etc. So we are here to make observations and to hear evidence and submissions about a whole range of things which will enable us to do that. I think when these processes take place, there is a tendency to want to think that it's looking at people. And the context for you, colleagues from the Road Accident Fund, being here and being asked to do what we've asked you to do is specifically so that we understand how that institution's systems are supposed to work in line with its mandate, in line with legislation, how it's worked before, how it works now, so that when we take submissions about where things may have off-ramped at some point, we understand how it is supposed to work, right? What the systems are. So do not worry that we will feel patronized. I certainly won't. I often say, explain this to me as if I'm a 5-year-old. I will ask several stupid questions. That's to develop my understanding of how the institution works. And this is also so that we do not make conclusions which are misinformed later, because we believe things should have worked in a particular way, but actually they are supposed to work that way. There is nothing wrong with how they work. So please be patient with us. As members of the committee, don't get tired even if a question gets asked again. It's so that we can develop our own understanding. And I also want to make an appeal to the members that making observations about the system really is important, because at the end of this process, we need to take lessons here and see how they can be applicable to other organs of state which are similar to the Road Accident Fund or thereabouts. That will sharpen our oversight. And so it's not just the conduct of individuals, it's also this ecosystem as a whole, whether it was working or not. We will, during the course of this week, hear from the ministry. I think that is happening later today. We'll hear from the Auditor General, for instance, in terms of previous audit outcomes and their observations thereon. We will hear from the Special Investigating Unit. All of that is to set a context for us to understand the lay of the land, so that when we then hear from witnesses later on, we understand the terrain in which things have been happening, and we can then make sharp observations about what is supposed to happen and what isn't. So having said that, I would like to hand over to the team from the Road Accident Fund to introduce yourselves, and thank you very much for sharing the presentation with the committee. The members all have a copy, and please be as simple as possible. Watch out for acronyms, because every organization has got its internal terminology. And I have noticed on Google, if I say Road Accident Fund, it also shows the Royal Air Force. If you say RAF, so please watch out for acronyms and other shortened terms. The members don't work in your environment. The members of the public don't work in your environment. And just take care to just say what things mean. So you will see sometimes I may make interventions asking you to explain a term that you are using. So I'm not upset. You haven't said anything wrong. I just want to make sure that every one of us can follow and understand what it means. So it won't be an interrogation. So all of you are here to deepen our understanding of the Road Accident Fund. Nobody here is being said to be in trouble. Okay, so please, you are here to assist the process and the members of the public that are watching these proceedings, so that we can all be better for it. Thank you very much. I will hand over to you to introduce yourselves and then get going.
Good morning, Chairperson. Good morning, members. My name is Tsepo Mwatse. I'm the Acting Chief Claims Officer at the Road Accident Fund.
So, sorry, just, yeah.
Good morning, Chairperson. Good morning, members. My name is Lance Johnston. I'm the Acting Regional Manager, East London RAF Offices.
Good morning, Chairperson. Good morning, members of the committee. My name is Bongile Mgwali is the surname. I'm the Acting Regional Manager for Pretoria Region. Thank you.
Good morning, Chairperson. Good morning, members. My name is Tabo Chak, Acting Senior Claims Manager in the Pretoria office.
Good morning, Chairperson. Good morning, members. My name is Dina Kubeka. I'm the Program Manager for Project Bukamuso.
Good morning, Chairperson and the members. Rodney Mkabela is my name. I'm the Acting Strategy and Transformation Officer of the Road Accident Fund. Thank you.
Thank you very much. Over to you. You've got a presentation to make to us. Thank you.
Thank you, Chair. I think we will screen the presentation. And I must say, Chair, that there's few changes that we made, and partly I think is to deal with one of the things that you said, explaining some of the concepts. When we were going through it last night, we saw some of the things that we could expand. We also removed some of the things that we thought are duplicates. But if members have questions in some of the slides that they're seeing in front of them, they can always ask questions.
Sorry, can I ask, if possible, if any of you are sort of connected to the Wi-Fi, if you can just send this version to the Secretariat so that it can be distributed to the members. Because as the members go through their notes later on in preparation for future, they just need to have the most accurate. But your colleagues can do that while you talk.
Thanks, Chair. I think when we received the brief, members, there were a number of questions that were asked in terms of the presentation today, and we would then go through those questions and take the committee through the answers that we have provided. One of the questions was to explain the claims process in terms of the Road Accident Fund 1996 and how the claims were flowing from 2020 to date, or how claims are flowing from 2020 to date. And I think from 2020, thereafter, there was an introduction of the new RAF 1 form. So we'll delve into that aspect of the presentation.
Welcome, DM. We will let you settle. Please continue.
And then, Chair, there was a question on some few questions that were asked on the integrated claims management system. And so the presentation will touch those areas. And then there was also questions asked about how queries are managed in the fund, but also questions were asked about the structure of the claims business unit. So we'll provide those answers. And Chair, there will be few of us that will be presenting. I'll start and I'll be going through the claims processes, and my colleagues will chip in when there are questions. But also there are some sections that will be presented by some of the subject matter experts that we are here with. So the first slide, Chair, deals with a claims process flow, and I'm going to start the claims process flow before the introduction of the RAF 1 form, because the question that was asked after this one was for the RAF to explain how the RAF 1 form rather works. And there was also a question on the impact, so I will provide some statistics around that area, and hopefully that will assist. So before the introduction of what I would call, Chair, the new RAF 1 form, for lack of a better word, a claim will come through the Road Accident Fund. So that's the start of the process. The RAF will receive a claim, and ordinarily it will be a form that will be filled. The old RAF 1 form would have to be populated with all the details that are required in that form. And a number of things, Chair, needs to be looked at when that form was submitted. The delivery method would have been either the post office, or somebody would walk into any of the RAF offices. So naturally, you've got 5 main centers or regions, as we call them. There's one in East London, there's one here in Cape Town, there's one in Durban, and then there's one in Johannesburg, there's one in Pretoria. The biggest one in terms of claims inflow would be the Pretoria, and followed by the Johannesburg. So most of the claims would be centered in the Pretoria region. A lot of the attorneys would submit claims in that environment in Pretoria. So when somebody enters any of the buildings of the RAF to submit a claim, it will be stamped. That would be called that would be termed lodgement.
Sorry, can I ask? So you said so the major centers that you said, is this where they walk in?
Yes.
Claims. So if someone is in Duzuma, where do they walk in?
So, Chair, we've got what we call customer service centers across the country, but they're not necessarily everywhere. So we've got some in your Limpopo side. You've got some I think there's one in Bloemfontein. There's an office in Kimberley. Colleagues will remind me some of the offices. Yeah, but there's a number of offices, but yeah.
Okay, you can finish us with that later on. Yeah, it was just. Thank you.
We'll provide the Chair. And what should be noted, Chair, in terms of the submission of claims is that also when people walk in or attorneys walk in to submit a claim, it has to be done within a particular number of years from the date of accident. Because if you then don't bring that claim in the RAF during a particular period of time, that claim might prescribe. So somebody might walk in, or a lawyer might walk in to submit a claim, and only to find that the claim has prescribed. Then we've indicated the various categories that cover the prescription period of a claim. If you were in a hit and run,
sorry, prescription being?
Meaning that your claim is not valid anymore. You should have submitted during a particular period of time, and then you came late.
Okay, all right.
Yes. So if it was a hit and run, you've got 2 years to bring the claim. If you come in the 3rd year, that claim would have prescribed in terms of the RAF Act. And where the driver, or what we call the insured driver, is identified, then you've got 3 years to bring the claim. But there's categories where, Chair, we've got minors, we've got people that are probably in mental institutions, or they've been diagnosed by psychiatrists not to be well. Their claims would not necessarily prescribe sooner than the ones of people that are not having those kind of challenges. So there are those issues. But also, Chair, all in all, once you have submitted a claim within, let's assume the 3-year period, because most of the claims fall in that category, where the driver is identified, the person can lodge a claim, they are okay, they are not minors. Then the claim comes through to the RAF. If it's a represented claim, so when there's an attorney, summons needs to be issued within a certain period of time, so that the claim then can, if you don't issue summons in a period of 5 years, then it will prescribe even if it's lodged. So if an attorney walks into the RAF and they lodge a claim on time, so it's not a prescribed claim, and it's accepted within the fund, and then they do not issue summons within a particular period of time, that claim again will prescribe even if it's sitting within the RAF. So there's that aspect. So when claims are submitted, you do have those challenges where people would bring their claims after prescription. So those challenges are existing, Chair. And
I'm sorry, so this is the most important part of this process, so forgive me. So you're saying that if, let's say, an attorney representing whoever submits a claim, and the claim is properly submitted, but it's not yet finalized, so you say it still prescribes?
yes.
Okay,
So
can you just explain that?
Yeah.
So in other words, so the claim is in process and then it prescribes. The reason I'm asking, and I suspect it happens to the members as well, I get lots of letters and things on Twitter, people saying, I submitted my claim on such and it's like long time ago. Yeah, and I haven't heard anything, or that's why I think it's important to explain why it prescribes, notwithstanding the fact that it was submitted on time.
Chair, I want Lance to deal with that. I want us to go into the Act so that members can have, the details of why this kind of things happen, because it's prescribed in the Act that a claim, if it does not follow particular steps, it would prescribe.
No, I mean, just explain it in layman's terms. This is that kind of process. So just say what the law says in simple English, so that we understand. Because one of the things the committee members might then, because one of the things we're looking at is the escalation in legal costs, right? It may be that what happens thereafter, somebody says, well, I submitted everything on time. You're telling me it's prescribed. I'm going to court. And you guys have to defend it, you understand? So that is why this is of interest to us. If it's properly lodged, but the period of prescription arrives while it's with you. Okay, Honorable Atkinson.
Thanks very much, Chair. And just in line with this issue of prescription, I believe the RAF Act requires 3 things from a claimant. If the claimant provides those three items validly, and the claim goes forward, but doesn't necessarily meet the requirements of your board minute, okay? So I think you put a whole lot of other issues in place. Can it actually be legally seen as prescribed if it actually has met the requirements of the Act, but not your board notice?
Okay, so can I ask that? You'll come to the board notice, ne? So I don't want us to go back and forth. So can we just deal with the call, then we'll come to the board notice, if that's okay. So please bank that question and respond to it when you get to that part of the presentation.
Thank you, Chair. So what would happen is that within the 3-year period for identified claims, a valid claim needs to be lodged at the Road Accident Fund. We've got certain time periods in which to object to the validity of a claim. If a claim is not actually settled within a certain period, an attorney has a right to issue summons against the RAF. If the RAF is not in a position to process that claim without receiving all the documentation over a period of time, after a period of 5 years, unless the attorney issues summons, that matter would have prescribed. And that is why summons is issued against the RAF. I will come later to the question of the Honourable Member Atkinson.
Okay, no, that's fine. And please be, like I said, please be patient with the members. You can see a lot of hands are going up, and that's because this is the most important for us in terms of our understanding. I'll just ask DM, I saw your hand,
Thank
and
you.
welcome.
Thank you very much, Chairperson, Honourable Chair, Honourable members and colleagues. Chair, I was advised that we're starting at 9:30, and hence my arrival at 9:30. It's no disrespect to the committee. Chair, can I, maybe at the outset just to indicate that our presence here is to give assurance and commitment to the committee of our fullest cooperation to the committee's inquiry, and we look forward to working with the committee in traversing this journey, and we will endeavour as the ministry to make sure that the department and the entity are fully compliant with your expectations. Of course, maybe what I hope the committee will from time to time appreciate is that this process is running parallel to legislative review and reform of the RAF as part of our response to ensuring that the entity works in a manner which is fit for purpose. We are at the tail end, if not having finalized the RAPS bill, to ensure that it now goes to Cabinet for onward transmission to Parliament to, amongst others, deal with the substantive issues which are of concern to the entity. Secondly, Chair, is to indicate that, as you know, we've got an interim board in place. Parallel to that, we have advertised for a substantive board, and that process is fully underway. And it is my expectation that should an leadership transition take place during this time, the committee will also be patient with us as we try to regularize the governance protocols within the RAF itself. We have also advertised for the executive positions, including but not limited to the CEO position, which closed on the 28th of September. So the filling of vacancies at this time is also a priority and in process. I don't anticipate that probably those positions will be filled in the midst of this inquiry, but in the event that a leadership change takes place, it is also our plea that the committee will bear with us in that endeavour. And lastly, Chair, the issue I would like to draw the attention of the committee on, and will be in your hands should we have to appear, is that there were matters which were not concluded in the audit process by the entity and the AG, and we have asked for late submission by no later than the 10th of October of our annual report to Parliament, as I believe that was ATC'd last week as well. We are working towards ensuring that we meet Parliament's deadlines. It is really not out of any other reason than the simple fact that there were substantive matters which required the attention of the board and the AG, and it is my expectation that the deadline of the 10th of October is met so that the committee can have full sight of the current and present situation of the Road Accident Fund, and so far as the audit process is underway. Chair, it is the intention of the ministry really to cooperate with this inquiry, and we believe that we will benefit as well, and believe that it is timely and that it takes place whilst we are in the throes of the legislative reforms and review of the entity. Now, the reason why I raised my hand was I wanted the colleagues to please speak in specific terms and not say in a particular period. Give the timeline of what it means. What is a claim? It starts, what's day one and what's day 180 and so on. Otherwise, we're not assisting the committee. So let's, from the outset, colleagues, not speak in generic terms. This is an inquiry of Parliament, and it requires specificities so that the committee can make informed resolutions at the end of its process. That was just the only reason why I chair raised my hand. Thank you.
Thank you very much, Honourable Deputy Minister. Really appreciate your comments, and we'll sort out the issue of time. There was a miscommunication. Thank you. Honourable Madlala, you had your hand up. Honourable. Oh, so let me start here. So I'll take everyone in turn. So each of you just ask questions, and then the team can answer. So we'll go around the table. Thanks.
Hello, thank you very much, Chair. Good morning to everyone. Now, I'm puzzled at a point where Road Accident Fund says only if the lawyer issues summons. And I get an accident somewhere in Ngutu. I'm not working. I go to the nearest office, I submit everything, I'm told it is correct. I don't get a response. So I don't have access to lawyers. How am I issuing summons to fight that my claim is not being processed? This is the number of our problem. So this thing of summons is just flagged as if all of us have access to lawyers to issue summons. We don't. I just want that. Yeah. Thank you.
Thank you. Honourable Madlala.
No, thank you, Chair. The DM actually covered me. It's the specifics. And don't look at us, look at the people at home. The process must also be educational. So we need to know, particular time is vague. Thank you.
Thank you very much. Honourable Ntenja, I don't know if you, did I see your hand or am I Dakyol?
I think Unkumbula, Chair. But I will ask a question anyway, because I'm also confused about this process. For starters, if there is a time frame and all that, what happens to areas where there are no RAF centers where people can submit? What happens in that situation? But what puzzles me mostly is the fact that after you have submitted everything, the case still gets prescribed, which means if RAF's officials or whoever is dealing with it takes their time processing it, you are at a risk of being chucked in the dustbin despite your injuries. So I'd like to understand that part. Thank you.
Thank you. Honourable Pila. Thank you, Honourable Ntenja.
Thank you, Chairperson. And good morning to DM and the team. And I want also to appreciate the commitment by the DM for the filling of vacancies, because as the team was introducing themselves, I had only one manager who is not acting, but the other team members are acting. I understand the claim process flow, but I just want to check, as you have indicated, Chair, that the complaints that are coming outside from the communities is that the RAF is taking time to process their claims. So I just want to check, how long does it take for the RAF to register the received claim, to verify and validate the forms that have been submitted to them? That is my question. Thank you.
Thank you. May I please hand over to you, Tim, to answer? And you can take the questions in turn.
No, thanks, Chair. I think thanks, DM. We will, and I think the Chair had also asked that we become as specific as possible. We'll try our best. Chair, where we please guide us to just nudge us to the right direction to say that information is missing, but we will try our best to do that. Honorable Mentor, in terms of the people that are not having access to lawyers, and I'm not going to beat around the bush, Chair, is that the RF must help people that are coming straight to the RAF and deal with those claims. And of course, that's the truth, that some people will not have access to lawyers. They would want to go straight to the RAF and deal with the RAF directly. And then some individuals will choose to go to lawyers. So I'm saying, I'm agreeing with her that when people approach an institution like the RAF, they should be able to get help from the Road Accident Fund and be guided through the process. And within our various offices, we've got working centers where people can consult. So there's people that are doing customer consulting. When somebody decides that they are going to walk in an RAF office, they're attended to by particular individuals that will guide them through the process and tell them how the process works. That's how it's done in most of our centers. Even in the customer experience centers, the role of customer experience centers that we have, and we might have to look at the channels, Chair, but the current ones that we have, they're precisely for that people, when they walk in, we've got one in the Northwest. When they walk in there, they need to be guided in terms of what they need to do if they wanted to claim from the RAF. Chair, the prescription issues of claims that are prescribing in terms of the board notice, I think we'll deal with that, because there's a slide or two or so that are dealing with the board notice and the RAF 1, and then we'll interact how that, the difference between prescription and objection of claims. We will be able to address that. I don't know if colleagues, there's other questions that you want.
Maybe in addition to what Mr. Moats is saying, in relation to what Honorable Mente has indicated on direct claims, the organization over a period of time will assist people who are coming directly without attorneys, who are coming through to the customer service centers, to ensure that the lodgement of the claim happens in time in order to avoid the pre-lodgement prescription. And thereafter, in all the provinces, in all the regions, we have what we call the direct claims departments. Those departments are the departments that are dealing directly with the people who are coming without attorneys. The departments will literally assist the direct claimants in terms of getting the required documentation that they might need to ensure that the period of 5 years doesn't lapse without the matter being settled. So in essence, if there's a need for an accident report, that particular team, the direct claims team department, ensures that such important documents are sought and are brought to the Road Accident Fund via all different units that they have within the departments, with the sole intention of ensuring that the claim is made an offer, settled within the 5-year period.
No, please. So here's my suggestion, so I'm going to rely on you, Chief Claims Officer, that the best way, so become the choreographer here. So please delegate. So you'll get questions from the members. Just pick a person who's going to answer, because what usually takes time is that everybody wants to add, right? And then we carry on for much longer. So I think the question, and I'll come to you, Honorable Atkinson, and we'll come to RAF, this new form. My understanding, and correct me if I'm wrong, was that even if all the documents have been submitted and they are correct, if the period of prescription arrives, so in other words, you don't get back to the claimant or their attorneys, if that attorney does not issue a summons, then it prescribes anyway. That was the understanding. So please clarify if that understanding is true. That triggered a question by Honorable Mente to say, that being the case, it's even worse for a person who's a walk-in, who does not have an attorney, who is under the impression that everything is now going to proceed smoothly. And then they wait and wait and wait, and the thing prescribes. And please also tell us whether the Road Accident Fund, in both instances, nonetheless sends some kind of warning to the claimant to say, your matter is going to prescribe in 30 days. Or is it just left, and the person in their mind, I never heard anything from the RAF at all, and it's now been 5 years or 10 years, which is what we get as members.
I'll tackle the first one, Chair. I think when it comes to people that would have submitted their claims directly to the RAF, you'd recall in the past the RAF used to have things that were called road shows and so on. I think in those road shows at the time, they would be encouraging people to lodge directly with the RAF. That process had other issues that came with it, that you would find people that probably might have not been in accidents lodging. So a number of direct claimants were lodged within the RAF, but later the road shows also will be dealing with trying to make sure that those claims are finalized. So meaning that Mr. Chaka spoke about the direct claims department. What the department did ordinarily was to track people that claimed direct with the RAF, to make sure that all the required documents to finalize a claim are in place. Actually, to a point where RAF would take direct claimants, meaning where there's no attorney, to experts that were appointed by the RAF to try and settle the claim. So insofar as people that were coming directly, the RAF tried to assist by calling, reaching out and interacting with people that are claiming directly to try and finalize their claims. When it comes to claims that are lodged by law firms, the RAF does interact with law firms. And one of the issues, and I think it will dovetail into probably why then the RAF 1 form was introduced, because at the point in time when a claim is submitted in the RAF, it would not be submitted with documents that would enable the RAF to finalize the claim. So you would find a situation where a form is submitted, essentially maybe an ID would be there, but to finalize a claim, let's say somebody is claiming loss of earnings and they are alleging that they were having orthopedic injuries. So you need particular medical reports for that quantum to be determined, meaning you need an orthopedic surgeon's report. If this person has a head injury, then you might need neuros and psychiatrists so that the quantification must be done. So the process of finalizing a claim requires that that's why in direct claimants, then the RF would appoint those kind of people on behalf of a direct claimant. But when somebody has opted to go for a law firm, then the law firm would then take them through those assessments. And once those kind of documents are submitted to the RAF, it's then the RAF can make an assessment of the claim. But of course, RAF also has a right to appoint their own experts to finalize that claim, or rather to interact or to do the investigation rather, in terms of the levels of injuries that this person is having. So during that interaction between the law firm and the RAF of exchanging documents, if a period of 5 years arrives and that claim is not settled, and that claim is not finalized, and that claim is with a law firm, and a summon is not issued, that claim would prescribe, Chair. And that claim would have been submitted.
Okay, so that's something we will note. I don't think it's for us to argue at this point, but I'd just like to ask the members to then note. But I have this question. Is it possible that there are numerous people out there who are under the impression that their claim is still being looked at, and it is no longer being looked at all? Because I noted in your language that you say the RAF would try to, and I appreciate the effort, but I also have a fear that it also means you can't say that you are able to get back to everyone. And I also wanted to just ask this question about a notification, because I'm assuming that in your system, you've now claimed, if you were to draw up a report, it would tell you out of the 1,000 claims we've got in the system, 325 will prescribe in 30 days, as an example, or in 6 months or whatever. And the question that I had, is there any communication from the Road Accident Fund to the claimant or their attorney to say your claim will prescribe in X number of days? Because I would assume that to the extent that there is documentation that is missing, it triggers that claimant to then try and submit those documents. Or is your position that everything is just left and therefore the claim prescribed? And please help us with what then happens to that file when it prescribes.
I'll ask Mr. Mkabela, I think, to deal with the efforts that his team has been doing to do outreaches to claimants and the projects that he has been running from his department.
Thank you, Chair. I will be covering the queries management as part of Part C of the presentation. However, it is important to indicate, Chair, that we initiated what we call a backlog campaign. This was on the 3rd of March this year. And the purpose thereof was to reach out to every claimant out there, direct or represented. We started with an inbound campaign through the contact center, where we received approximately 1,698 inquiries. We settled 97% of those. But you will agree with me that that's a very minuscule number. We have hundreds of thousands, of course, those of those claims. We then started an outbound campaign. This is us now calling all those claimants. As I'm talking to you, Chair, we have just exceeded 65,000 claimants that we've called directly. The purpose is to say, Mr. So-and-so, we still are awaiting documents that will enable us to process your claim. We do have challenges, of course, where some of the claimants have given up. And there are reasons why so. In most instances, they are the represented claimants who will even say that I haven't heard from my lawyer for X number of years. So it's a mixed bag of all these challenges, Chair. But when I go through the presentation later on, you will see how we manage those. Because for us, every claimant is in our book, it's a liability. It doesn't matter whether that claimant is still represented or not, we have to assist them. But I will cover more details later on with respect to that. But as I'm talking to you, the intention is to eliminate this backlog so that we're able to deal with those claimants as they come through. Thank you, Chair.
No, thank you very much. How far back are you going in terms of who you phone? Which years qualify?
It's all out, Chair. Whatever is in our books, we go for those. We call them to understand where their claim is in terms of the status. But we also find cases where, Chair, people are just trying their luck.
No, we
go as far back as what we have in our system. We don't discriminate in terms of the timelines.
No, I know. I am trying to also remind you of the Deputy Minister's injunction. So when you say as far back, could a 2014 claim be one of the people that you are calling, for example?
Chair, the answer is yes.
Okay. All right. Honorable Mende and Honorable Non-Danger. Sorry, this is the... so please bear with us.
No, Chair, thank you. We're still going to the... when they decide to pay, but we're in the process. Please tell us, prescribed or not prescribed, or everything that is in the system that was ever claimed you are looking for, so that the people that are writing to us, we can tell them, pick up your phone, they are looking for you. Are you phoning everyone who's in the system? And secondly, I'm reminded that DM would know. I'm reminded when you say you are calling those people and then they must submit whatever is outstanding. What method should they utilize to send document? Because I'm reminded of a time when we were there, DM, and there were piles and piles of letters or forms of people that they sent through post. I think we visited more than 3 plants. All of them had piles and piles of unopened posts. And then a person is sitting waiting for a response, yet their letter is in those piles that are not opened. What is the system now? And how are they responding to your call? Are they being provided with an email? Do they fax? Do they WhatsApp? What is it that they do? Thank you.
Through you,
Yeah, sorry, we'll just let the members ask and then
All right,
we'll
thank
come back to you. Just take note of the questions.
Thank you, Chair. Just to add on the previous question, just clarify that part of prescribed and the calling that you are saying you are making now. Because if you are saying that you are calling everyone, including those that are prescribed, technically it means that no one is prescribed currently, because all are active and you are calling them. If my understanding of what prescribed means. And if that is the case, let us just say it like that, that currently we're calling everyone to say, come through, let's say, see where your case is and so forth and so on. Or if there are cases that are prescribed, we're only calling people within the last five years, if that is the case. Then the second one is a question, I think I'm reminded of a case here, of what happens when the attorneys say to a client, they have been offered a particular amount by RAF and they declined it. And this is a practical case of some that I interacted with. It was a matter of around 2012. I think 2 years after the accident, the lawyers claimed that they were given an offer by RAF which they declined. They did not even tell the client how much was the offer, by the way, and why they declined it. But fast forward, there was some 6 years in between where there was no communication and so forth and so on. And latest update from RAF, which is as late as last year, was that RAF is awaiting a medical report of the client, meaning the client must go back to the medical doctor that they went to in 2012 and try to find the records of the report or go and do another assessment 12, 14 years down the line to make a submission. So those kind of matters, are they regarded as, because I want to assume that because there was an offer, full documentation was submitted. So, but now there's another set of documentation that is required. What happens in that? Is it regarded as prescribed? 5 years has lapsed. Is it regarded as an ongoing or matter that is set anew? I just need clarity on those kind of matters. Thank you.
Thank you very much. Honorable Atkinson.
Thank you very much, Chair, and thanks to everyone from the Road Accident Fund. I'm interested in this issue about people being able to come in directly to you, because from what I've been hearing is that it is an extremely difficult process for an ordinary person to do. What I would like to know is what percentage of successful claimants are direct claimants versus those via lawyers. Okay, so in the last 3 years, of your payments made out to road accident victims, what percentage actually came in directly versus lawyers? And then the second point I wanted to make was, and this really does affect this whole idea of prescription, is the original idea in the Act was that to get a legal claim registered, you just needed to provide three particular items, okay? Then your claim was in claim, basically. It was kind of in process. And from there on, you could ask for all those other documents for an accident report, medical reports, various other things, okay? Now, the RAF 4 has asked for all that stuff up front, which might be a near impossibility to do, because to ask for some of these medical reports and everything might not be possible to do within the time period that you require. So you actually make it a much more difficult process for the public, that RAF 4 form, where it could have been made easier by sticking with the RAF 1 form, which is actually the legal situation, because I believe your RAF 4 form has been thrown out by the courts. And that the RAF 1 form could be followed, and then people could provide the additional information as required during the time period. Then I think you'd have less of a problem with the prescription if that was the case. But I would particularly like to hear the percentage of direct claimants who've been successful in actually getting a payout from the Road Accident Fund. Thank you.
Honorable Nadenja.
Thank you, Chair. I'm mostly covered by Honorable Madlala on the prescription. But what I would like to check on is to say, the gentleman says they are calling everyone. Should the person have changed the phone or doesn't have a phone, what other modes of communication are you using besides calling them? Thank you.
Thank you. Members, are you happy? Honorable Neil May and then Honorable Beasley.
No, thank you. Good morning to the Deputy Minister, the team here from RAF, and Chair, and our colleagues here. In reality, how many, and I'm sure I might have missed that, is how many claims have prescribed in your hands? And how are you dealing with those? Because if you are calling the clients and they are prescribed, surely that is not possible. The second thing that I wanted to check with you is that currently, if I'm not mistaken, you do not have a panel of specialists to assist victims on a large scale. How are you managing with regards to that? The other area that I would want to check with you is that you have attorneys acting on contingency fee basis. For the clients have attorneys acting on contingency fee basis. And obviously they have a vested interest in pursuing the highest possible settlement, generally at a cost that to the claimant. And how are you advising? How are you managing that? Thank you. That is possibly the role between attorneys. You have attorneys that are watching what is happening and have inside information, and therefore are with our and these we are talking about. They are contingency fee attorneys to the clients, so therefore they will go for the highest payout.
Honourable Beasley.
Yeah, thank you, Chair. So my question is about prescription. Can a legitimate claim actually prescribe? So if somebody's put in all the documents, and when does the date of prescription actually start? Because we know about the incompetence. So if somebody's done all the work and they've submitted all the documents, but they haven't followed up in 5 years, does that claim actually prescribe? And when does the actual when does the actual date of prescription actually kick in from the 5 years? And I think Honourable May asked a question. I think it would be great to get an understanding of how many claims have actually prescribed per year. And then my concern is from a financial point of view, the amount of liabilities that actually haven't been recorded with these prescription claims that are sitting in an actual document that nothing's actually done to them. There must be a massive, massive liability building up. Thank you.
Thank you very much. Can I just ask that please note the question? At some point we'll talk about the litigation, right, and things. Okay, so note Honourable Neil May's question about the lawyers. Let's deal with it then. And also when you go through the presentation, when something has now been canvassed, you don't need to re-canvass it, but you can just refer to the fact that we've already discussed, and then so that we're not here until 11 p.m. But please go ahead.
Thanks, Chair. I think Mr. Mukabela, maybe tackle all those ones that we're dealing with the outreach programs, and then we'll.
Through you, Chair, thanks. I indicated that my presentation was going to cover the queries and complaints section, but I'll attempt right now to respond to the questions which have been raised, Chair. Chair, we established a contact center last year to make sure that we've got a sufficient cover from the RAF side. We have 300 young people who are part of that contact center, and their role is to make sure that we reach out to the claimants. The question asked was, what method are we using as the RAF to contact those claimants, but also how do they furnish us with the required documents? We are digitally present, Chair, in the sense that through the contact center, claimants are able to call us. There's a contact center number. There's an email that we make use of. We are also present across all the social media platforms here. I'm talking about all your Twitter, Facebook, and all of that. As I'm talking to you, the adoption of the digital platform for us to interact with our claimants is improving at a much faster rate, to the extent that we're able to even resolve most of the issues through the contact center, where they don't have to be walking distances to submit the document that is required by the RAF. I hope I've responded to that question. I think the next one was with respect to the prescription, which I will leave it to my colleagues to respond to. But I'm happy to, as I've indicated, to go deep into how we manage queries, because there's a detailed process on how to do that. And we have clearly defined metrics to assess the efficiency thereof. Thank you, Chair.
Thanks, Chair. I think I want to tackle Honorable Madlala's question on a claim where an offer was declined. So naturally, Honorable Madlala, it happens that so the agenda of the RF is to try to settle claims. Mainly that's what we need to do, to settle claims. And an offer will be made, and sometimes attorneys would then have a view that maybe that claim or the offer that is given is not adequate, and they would want to motivate for an increased amount. So they'll either provide case law or they'll provide, amended medical reports that then deals with why a claim must be higher than what would have been offered by the RAF. So ordinarily in those spaces, when a lawyer has declined a claim, or rather an offer, they should have informed that client that the RAF has made an offer, and this offer was this much. We have not agreed to take the offer because of these reasons. We believe that you deserve more, and this is what we are going to do over the years to make sure that the RAF either revises their offer, or essentially want to take the RAF to court because they are sticking to their offer that they gave. So naturally, either new evidence will be provided, new documents will be provided. So there should be interaction between the lawyer and the client, but also interaction between the lawyer and the RAF to say, here's my new evidence, this is why I want the offer to be revised. And sometimes we then have a situation where medical reports would then get outdated. So essentially then the lawyer will take back in that particular case, I'm assuming that could be the case, where the lawyer would have to take back this claimant to particular medical experts to try and update the medical reports so that they can then indicate why they want an offer that is higher than what was offered by the RAF. At least when I listen to that case, my thinking is that the lawyer would have thought that there's more money that can be given to that claimant, probably given the injuries or what they believe is reasonable on their side, as opposed to what the RAF would have offered. But in that case, the attorney should have indicated to the lawyer that there was an offer by the RAF and they're declining it, and the reasons why they are declining that offer. I'll ask Lance to tackle a few of these, and then Sibongile as well.
Thank you, Chair. To come back to Honourable Atkinson, when it comes to the documentation, we mentioned 3 documents. Yes, in terms of Section 24 of the Act, the required documents to lodge the claim is the RAF1 form, which needs to be completed in its entirety. It needs to be stamped and signed by either the claimant or their legal representative. The statutory medical report or medical records in terms of the judgment of Basuku is also something that we should be looking at in terms of the claim. And then there is a third requirement that the Section 19F affidavit needs to be provided, which states how, when, and where the accident had occurred. So in terms of the RAF Act, those are the standard documentation that is required. We will share more information in the presentation in respect of the new RAF1 form. Thank you.
Thanks, Chair. I will take the question about how long does it take for RAF to register, verify, and validate the claims. In terms of the RAF Act, RAF have got 60 days to verify and validate claims. That 60 days. That 60 days is calculated differently depending on how you submitted the claim. If the claim is submitted via post, which means that it must be a registered mail, not just a normal mail, it should be a registered mail. It's used from the date that it was sent to the post office. Then if you have brought in through a walk-in to the RAF office, then that's the date that then you would have submitted the claim. So that's how then that 60 days is validated. That's how that 60 days gets to be calculated. Then RAF have got 60 days in terms of us to be able to verify and validate those claims. I think from RAF we have been, I think it's one of our APPs that has been on with us, I think, for quite some time, and it's an APP that we have been achieving it. I think we'll talk about it in terms of the board notice now, how it's changed in terms of now being done through pre-assessment. I think when the attorneys are bringing in the documentation, but it's done within 60 days, Chair.
Okay, let me just ask a stupid question. So are you saying in the case of registered mail, when does the clock start ticking? Does it start ticking when the post office clerk hits the stamp on the letter? And then typically, what is the length of time it takes between that incident in Mkanduli and it getting to you in East London, I suppose? What is usually the length of time?
It's the challenge I think we're having as RAF chair, especially on the post office. I think with the challenges I think that we are having, I think with our entity, the post office, in terms of delivering or getting those documentation. We are correct. It starts from the date, then the clerk at the post office stamps it. That's the date we utilize, not the date that we receive. So if we have received it after a month, or depending on how long do we get it, then that 60 days is counting. It's not waiting for us to receive the documentation. That's the challenge we're having.
Okay, so I'm going to ask a series of questions to try and kind of help us through the process. So we're now going to use a hypothetical claim, right? And that claim, so what you are saying is that when the registered letter or registered mail item, right? Let's say a letter, envelope, arrives at your offices after 15 days. It gives you 45 days to respond, to give feedback to the claimant, to say this or that and the other is missing, right? Okay. And I'm assuming that, so somebody just take me through. It doesn't have to be you. Somebody take the committee through the process. The claim arrives. Somebody looks at the envelope. Alternately, I suppose there is an email as well. It can be emailed by the claimant. Does that happen? No. So there is a walk-in. There is registered mail. Is there any other method by which someone can lodge?
No, Chair. In terms of the RAF Act, it's those two that has been it's prescribed in terms of the Act. It's registered mail, or it can be brought in physical.
Okay, so in other words, so I can ask a courier to deliver it, or in the case of attorneys will get somebody, and then somebody signs for the claim to acknowledge receipt. Is that how it happens, or does it get dropped in a box?
Chair, and I think questions are important, and so we must stick to remember the first slides we're dealing with before the RAF.
Oh, okay. So I am now jumping the. Okay, maybe just continue up to a point where the process is complete, and then we'll ask questions at that point. Is that okay? All right.
No, thanks, Chair. So I think I had dealt with the receiving of the claim. I think that's where we got stuck. So I'll move to when a claim has been received and has been stamped. So it will be those two channels before the RAF1 Act. the RAF1 form that was introduced. Then these claims would have been received from the post office, or somebody would have walked into an RAF office to deliver these things, and naturally then at the point in time they will just stamp that form, and then that claim is lodged, and that claim then goes through what we call the registration process. So the claim is then registered in the system, and that's when you identify what we call a link number. So it's basically your primary key that we identify claims with. It's called a link number. When people are having that link number, it's quite easier to then for them to query, including lawyers or direct claimants. If they have a question, if they've got, but their IDs also can be used to identify their claims. But naturally, we give what we call a link number. And then the claim is registered and is given that link number. Then it goes to the stage there where we're going to verify. So there's a number of issues that needs to be verified. One, the identity of the injured party or the deceased, the identification of the third party, meaning the insured driver, whoever that would have caused the accident, and the date, time and place of the accident, so that we can check that there was really an accident that happened. Those processes will involve interacting with police reports and so on. The identity and registration numbers of the vehicles that were involved in the accident, because sometimes in the form that you might get particular details that are differing with what's sitting in the police reports. So the verify and validate claim process looks into those kind of things. And a completed statutory medical report is looked at, and also we verify if the doctor that completed the statutory medical report is a registered doctor, a practicing doctor, somebody that needs to be doing medical work. So those kind of things needs to be looked at, so that these things are not then done by people that are not medical practitioners. And at the verify or the VNV stage, verify and validate stage, the mortality checks are also done. Once that process is done, if there's a problem, Chair, with that process, then this claim would be objected. That's the process where we said that it needed to happen within 60 days. From the date we stamped it, or from the date of the post office stamp, and you are right about your 45 days calculation, that if we receive it after 15 days from the post office, then we've got 45 days to then go through the process where we can get to a point where we say we verified the claim and we found something wrong with the claim, and therefore we object to the validity of the claim. If those checks that I said, identity of the injured, identity of the third party, date and time and place of an accident, if there's a problem with one of those things, then that claim will be objected to, and that needed to happen within 60 days. And then if there is no problem with the process of validating that claim, then that claim would move to where we do merits determination. This is where then we look at the involvement of the person in the accident, whether somebody was drunk, or whether this person was driving alone and they rolled with the car alone, or they hit a tree. That's where you then do your merits assessment. Things that we look at there, Chair, is whether the claimant was indeed involved in an accident. So the accident in question, whether the people that are claiming were part of that accident, and whether the injuries that are sustained by the claimant were actually injuries that were sustained at that alleged accident. And also, Chair, when we deal with merits, we also check the officer accident report and the docket from the police. The statements from the claimants are looked at. The statements also from the driver that could have been involved in an accident, or the insured driver, or the person that would have said that they caused the accident. Their statements are looked at, and that process is done to determine the merits. This is where you find then the RAF might say we consider when somebody is a passenger, they were naturally not driving, so they're most likely not going to be at fault, unless if you say somebody else says they were not wearing a seat belt and those kind of things, those could be looked at. But ordinarily when somebody else is a passenger, then it's an easier merits assessment to do. But when there was a driver, there's a number of issues that needs to be looked at. But of course, even when somebody was a passenger, you then need to determine if they were really in that accident, even though when they submitted claim, they would have said they are a passenger, but equally, were they really a passenger? Because you might find instances where somebody says in the claim form that they were a passenger and actually they were a driver of that vehicle. So that's when we do the determination of merit. So those factors are...
I was hit with a stick at Mkiti there in the village in December, while we were doing stick fighting, and now I go to the road accident fund.
So that process looks at that, Chair. I think there's instances of people that I think fell from trees or fell from stairs in their houses that would submit claims in the RAF. So the merits process would look really into whether the fund is liable, and this is where also you then find apportionments done. And I think I must mention this because the committee said we must go into deeper details, where after determining whether somebody else would have been partly negligent or a particular way they were having, when they were driving, there were particular things that they did. You might find that the RAF says we will pay 70% and we are portioning your claim between 70-30, meaning that whatever will be your payment when the claim is finalized, 30% will be deducted from that payment because of particular behavior that you might have exhibited when you were, busy driving that vehicle. In some instances, and I think the easier one is if it can be proven that you were driving, you were all alone, and then you either slept and then hit a tree and got injured, then the RAF would not be entertaining that claim. And I need to mention that, Chair, because of the details that are required by the committee. So that is the merit stage. And also the merit stage, there is a potential, Chair, of the example that I gave. That's when then a claim gets repudiated, meaning that the RAF does not proceed with that claim because there is a repudiation and there's various reasons for repudiation. I think I have mentioned one. And then when merits are concluded, meaning that there's and also merits share, it's an offer. The merits issue becomes an offer as well. Like I said, that sometimes you then do some apportionment. So an offer is to be made to the claimant either through their lawyer or directly to a claimant to say, after the RAF has assessed the conditions or rather the manner in which the accident has happened, you are given an offer of 80-20 in terms of the merit assessment. And sometimes those things can bring in disputes, especially from legal practitioners who might have particular evidence that they have that might want to push them, or rather they would want to push for the claim to be a concession, meaning 100% no apportionment. So that stage also attracts disputes, especially where you do apportionment. I think that is important to mention. And sometimes then it gets into exchanges between the RAF and the representatives of claimants to deal with issues of merits. And then when the merits are concluded and there is an agreement between the RAF and the claimants around the merits, the claim would then move to the determination of quantum. This is where an example that was given by Honorable Madlala on an offer that was made to somebody else. And again, when an offer of a particular amount is made to a claimant or to a legal representative, they have a right to say that they want to contest that offer because probably it's not what they were looking for, but of course then they would have to prove why that claim has to become more than what they are looking for. So this is where ordinarily legal practitioners will either present case law or arguments around why the offer that was given by RAF is not adequate for their claimant. So there's a stage where quantum is determined. So, and Chamas mentioned that at the determination of quantum, this is where your medical reports become important, or particular documents. And I must pause and then maybe get into details because there's various claims that come through to the RAF. Let me deal with the first portion, which is problematic, is what we call the death benefits. When somebody else has died in an accident, there's particular documents that RAF would want. And when we deal with the requirements of the RAF 1 chair, I'll take the committee in each document. I don't want to go to that slide, but I just want to say that for purpose of details, I have a slide that details that when somebody else dies in an accident, then the RAF has to pay and determine quantum. What are the documents that must be sitting with the fund for the fund to make a determination of an amount that can be given to the family or the claimant of the person that passed on? And then also you've got funeral benefits where a family or a claimant would claim on behalf of somebody that passed on what we call the funeral claim. There's particular documents that would ask that must be given to the RAF so that we can come to a particular determination to say this is the amount. The then you've got what we call the injury benefits. This is where somebody did not pass on in an accident. They got injured in an accident. So, and of course, injuries will differ. Others are going to be having head injuries. Others are going to have orthopedic injuries. So to determine that quantum, those documents must be in the hands of the RAF for the RAF to be able to determine what is fair compensation. Not only that, but of course, this individual would have been employed in a particular profession. They would have to provide that kind of collateral information, because the calculation of the quantum amount in terms of your injury benefit, we look at your age, we look at where you're employed. That's how the system is now. And then we look at the types of injuries and the impact those injuries are having in terms of your employability going forward, or in terms of your growth going forward. So that's why when these documents are not sitting with the RAF claims officers, it is then impossible for them to make a determination of what the quantum should be, because for them to make a determination of the quantum, they then need to look at those documents. And of course, Chair, if those documents are existing, an offer would be extended to the claimant, and the claimant, for an agreement to be reached, the claimant through directly or the claimant through their legal representatives, they would have to accept in writing to say, I've seen the offer that you are giving me, I accept the offer. And when that offer is accepted, then there is an agreement between the RF and the claimant in terms of the quantum amount that was accepted, and there's the quantum amount that would need to be paid to that claimant, either directly or through their legal representative. That's the process, Chair, that just before the introduction of the RF1, it was going through those stages. And I think when I go to the RF1, I will indicate where changes happened. And Chair will indicate if I need to elaborate on a particular point.
Yes, yeah, I'll ask you some stupid questions, but I see the DM's hand is up.
Sure.
Thank you, Chair. I wanted to beg your indulgence with the committee members if we could go to the REF1 form and then circle it backwards, because I think it helps to explain the scope of requirements at each point. So, because, I mean, just at the start of it, it answers the critical question of unrepresented or represented, and it begins classifying the process flow. So I was just wondering, Chair, because I think that may put a particular context to the detail which is being presented here. Thanks, Chair.
No, thank you. No, you and I are on the same page. They are, before we get the questions that I'm going to ask very simply. And so if we could please just have an exchange. And I'm just going to make some assumptions here, and then you just tell me where I am mistaken, right? So somebody can claim because they're injured, and the extent of the injuries varies. Someone had a broken finger, broken arm, broken leg, all the way to somebody who's confined to a wheelchair or confined to a bed. And they, in some instances, they can no longer do the work that they were doing because they worked in construction and they've hurt their back, etc., etc. So there is a range from just glass cutting your face to serious injuries. So that's the first, right? So I'm correct in terms of that range, all the way to somebody who has died. Now, I just want to understand from you who is responsible for securing the documentation that is required. In other words, I'm assuming, and this is where you need to correct and fill the gaps, the police report, I suppose, would need to form part of it. Somebody needs to prove that they were in the accident on the day, etc. We don't need to go through the whole list. Who is responsible for compiling all of that information? And I'm assuming that it is required for compiling all of that information for the Road Accident Fund. And please then just list, you don't need to just list the things that are needed, right? In order to get to a point where you can at least make your first assessment. I am then going to use the case of somebody who was in an accident in somewhere in Bizana, in the Eastern Cape. The type of claims that you get when it comes to the amount of money that the claimant has, others will say imali amatambo, and they just submit and they don't know these things, right? Because we've got a different level of understanding and education, right? How does a walk-in get assisted to make those kind of claims? Does the person who assists the walk-in say, where is your son, mama? No, my son is actually at home. They can't even get up and that kind of thing. So just take the committee through that process of screening in the interview with the claimant. Or is it a case of there is a clerk there, they look at whether the documents are there, and they say, okay, sharp, stamp, off you go. You also mentioned a link number. So just simplify it again. When you go to lay a case at the police station for whatever, theft, you will make the statement, you will not get the case number immediately, you will get sent an SMS, right? Just please help us understand. So now I've been there as I walk in, and I get the I have submitted everything. When do I get the link number? How do I get the link number? I'm assuming the link number is your RAF number. So when you call, you will use this number, right? And I'm assuming this is then explained in the initial interaction, right? Can I also ask, so if the person comes from where I come from, they really might not know how to quantify these things. I am assuming that you must then find a way of getting the patient to East London or to Mthatha, but typically for some specialist functions, they must go to East London. To get these assessments made, who activates that process? And when, therefore, is the submission deemed to be complete? And maybe you'll still refer to what is on this slide as well. So I've got all of these questions around how the process works, because there is an accounting problem, which is part of why we are here. There is an accounting problem, which has kind of showed itself up in matters that you were not involved in terms of the quantification of liabilities. Because that's very important. Those specifics are important, right? And also the point at which, therefore, one might feel, I actually need an attorney. This is too complicated for me. And we haven't gone to RAF 1 form. So in other words, all I know as a lay person, I can claim from the Road Accident Fund. Someone is going to say, but Sipo, you used to work in construction. You can't. You actually need to claim for loss of future earnings because you can't, right? Sipo doesn't actually know what the hell that means. So I just want us to go through it if you can, and please just say all of this in layman's terms so that we can understand. And then once you've done that, we'll go to break and then come back and deal with the RAF 1 form.
Thanks, Chair. A walk-in, a direct claimant, as we call the claimants, will walk into the Pretoria region or Johannesburg region with bare documents that the person would have, because the person is a lay person. What will happen is that a unit that is set there to assist the direct claimants will take the documents. I'm talking about the old now, before we go to the yes. They'll take on the documents, provide the link number.
No, so just remember, I said, please say the document. So to just say, this is what the person needs to get, and this is who's supposed to bring them, etc. Or do they get assisted once they've walked in? Because they might not know. So if you can just tell it like we are talking outside.
Yes. So generally they will bring in their affidavit that says that they were involved in an accident and hospital records. So mainly, that's basically the documents that they will bring. Just to indicate that I was in an accident, here's my affidavit, and here are the hospital records. So the person will get a link number. The documents will be now taken to the direct claims. It will go through the VNV, the normal process. It will go through the VNV, and because it's a direct claim,
What's a VNV? Sorry,
Verification and validation. I'm sorry about that. It will go through verification and validation because it's a direct claimant, and the system, the way it was done, there would be a special channel in terms of how the direct claimants will go through, whether it's a validation and verification up to merits. And the importance of that was exactly to deal with those matters in that sense, knowing that these are matters from direct claimants that need to be dealt with in a way that will be assisting our people. So having seen that the documents that are outstanding, when it reaches, for example, in the merits departments where an assessment must be done in terms of accepting or denying liability, there are many documents, like, for example, an accident report that wouldn't be there. So at merits department, for them to be able to know whether this person was actually involved in an accident, because you might have the hospital records that indicates trauma, but the trauma that could have came through being assaulted, for an example. Now, the merits department will need an accident report that will verify that this person was actually involved in an accident as a passenger, for an example. So at merits department, they will get an assessor that will get the necessary documents that we need to verify that the person was involved in an accident, to satisfy themselves that RAF should accept liability in this particular matter because the person was involved in an accident. So having gone through that process, up to the merits department is satisfied that the direct claimant was involved in an accident. They concede merits, guy is a passenger, merits offer goes to the direct claimants that, yes, your merits are okay, you have a claim. Then the matter will proceed, like Mr. Mwase indicated, from merits to now determining the quantum aspect.
So just to be sure, so now the person has walked in,
yes,
and so you are now, as Road Accident Fund, yes, doing the verification.
Yes.
Okay.
Yes. We are doing the verification. On top of that, over and above that, we are assisting where the necessary documents are outstanding. I've given an example of a very crucial document, the accident report. So we get the necessary documents. It goes to now assessing whether the RAF is liable or not. Assessment of merits. We're happy with that. We concede that RAF is liable. The merits are out of the way. The matter moves now to direct claims department, where they're going to deal with the quantification of the matter. You indicated very well that the person is a layperson, wouldn't know how much to claim, for an example. Let me give you an example of an injury, an orthopedic injury, a fracture of the femur. The guy has a fracture of the femur.
Please, so say someone has broken a femur is on the leg, or
yeah, it's on
please, you know, I have tweeted to say that people must watch because they can be educated. So say someone has broken a leg or something, you know, yeah, please.
Yes, the claimant has broken a leg, and the guy was working at the mines, for an example. So what we will do at direct claims department, together with the medical department, working together. Because remember, the guys who are working at direct claims would be attorneys, not necessarily medically trained. But they'll be assisted by the medical department, people who are medically trained. So the direct claims department will now, in conjunction with the medical department, looking at the type of injury the claimant has sustained, refer the claimant, schedule everything, refer after having made an appointment with what we call the RAF4 doctor. Now, this is the doctor that will determine the seriousness of the injury. The department will make an appointment for the claimant, inform the claimant that this is an appointment. Obviously, they will talk together in terms of dates and say available on this particular date to see Dr. So-and-so at such a place, at surgery. Then the department will also even accompany the claimant to go and see the doctor. The RAF doctor will make a report and say, this is a very serious injury. The importance of that, at that particular stage, the department now is in a position to look at making an offer for what we call general damages.
Sorry, stupid question again.
Yes.
The doctor, at what level of specialization is that doctor? Is it a GP? Is it a physician? One. Secondly, are these people that work permanently for you, or do you have a panel of doctors relative to where the person may be that you send to them to say, go to Dr. XYZ? How does that work?
Yes. The doctor will be a GP, but trained on what you call the AMA guides. So the armor guides is a system that is used to determine the seriousness of injuries. So the guy will be on the panel of medical experts, specialists trained in armor guides, relatively in an area where the claimant will be residing, to make it easy for the claimant to attend the appointment. So eventually we'll get the report from the RAF doctor that says this person has suffered serious injuries, this person qualifies for general damages. Now the importance of that is that at that particular stage, you're in a position to now make an offer independent of the rest of the heads of damages that you have, because a claimant can have several heads of damages for your general damages, your loss of earnings, your past loss of earnings. So, but at that particular time, because remember the guy is in pain, the guy might be in debt at that time because he's no longer going to work. Now you're in a position to make an offer for general damages because you have a medical doctor that says this person qualifies for this. Immediately, the team will make an offer for general damages. General damages that are based on case law. At the RAF, we have what we call, what's the name of the place? Quantum book, yes. We have what we call a quantum book that will, based on case law, relative to the type of injuries that would have sustained, the latest case law. For an example, for that for that humerus injury or the femur injury, the leg. For the leg, the quantum book might say 350,000. So what we've implored and encouraged the team members for consistency and to ensure that for any particular injury you provide the same amount in terms of making an offer. The guys will look at the quantum book and say, for this leg injury, 500,000. So at that time, we make an offer for general damages. And again, together with the assistance from medical team, they look at the possibility of this guy needing medical assistance going forward. So at that particular time, you can make an offer for general damages and an offer for undertaking to cater for your future medical expenses. So interim, you get an offer for general damages, you have a certificate for future medical expenses. Whilst the team is investigating and looking at possibilities of your future loss of earnings. Yes, the guy was working at the mine, or the guy was a construction guy. Now, because of that injury, that will take forever. Or even if it heals, it will still give him problems going forward because the type of work he's doing, he'll be required to walk a distance, things like that. The team, together with medical department, they'll say it's an orthopedic surgeon, orthopedic injury. Now we need an expert in that field. Let's make an appointment for this guy to go and see an orthopedic surgeon who will be able to tell us about how long and in the future how this injury is going to affect the claimant. Then an appointment is made for an orthopedic surgeon who will give us a report and say, this guy, based on the type of work he is doing, he might not be able to work until retirement. There's a possibility of 5-year premature retirement. We get that report. We send the claimant again to an occupational therapist. Now, this is an expert in terms of how people are doing the things at work. Expert will go to work and look at the situation, how the guy is working. We get that report again. Now, at the time, we're having 2 reports of experts in terms of how this person will be able to work going forward. Then ultimately, the same team will ensure that they take the claimant to an industrial psychologist. So all those guys are experts in terms of building up a report for future loss of earnings for the claimant. Because the claimant is a layperson. The claimant doesn't even attain. And in the end, the RAF again, collectively now, will be taking all those reports and handing over to an actuary. Actuary who will independently determine the rands and cents that we need to offer the claimant. So if you look at it in essence, this is a direct claim, but the offer would have been independently assessed by experts in various fields, up and including the rands and cents by the actuary.
Thank you very much. I get it now. Okay, so that's why I said explain it as if we're sitting outside, because it tends to simplify, and I'll come to the hands. I've just got this question. What is the difference between that and a claim facilitated by an attorney. And to make the answer quicker, we'll make an assumption. The attorney's value proposition is that I'm going to get all of these things the RAF gets for you. I will go and get them for you. You don't need to leave your house. I will go and collect all of that information. I will go to the police station. I will go and get the medical report. In fact, I will even find you a neurologist and an occupational therapist and so on. So the layperson's claim starts off like this, and it eventually becomes this size. The attorney's file arrives thick already because the attorney knows the process and that kind of thing, and that in essence becomes the opportunity in the market for an attorney to get involved. Would I be wrong in that assumption?
Thanks, Chair. I think if we're looking at it as before the 2020, we will say that then, in fact, before the introduction of the new RAF form, then you are partly wrong. Let me explain. What the attorneys are going to assist the claimant is to go and get the police reports, but remember, the medical experts, when they submit the claim, they don't have the report of the medical experts. So that one, they will refer the claimant as the claim has already been submitted to RAF. And it's only after the introduction of the RAF one where then it was made compulsory that you must submit, including all these medical legal reports, which is all of these experts that needs to be appointed, and then you must submit it. Yes.
Okay, so and we'll get to RAF 1 form just now. So let's park that. I just want to complete this here now. So what I need to understand specifically. So I was once in an accident. I didn't claim because I hadn't told my boss I'm not at work. And I was very eager to get back to the office before he knows that I was in an accident. But there was a lawyer there. There was a lawyer there who said to me, "Hey, here's my card. This is now 2000. Ne? Here's my card. We can claim." And I was like, this thing is maybe my boss is gonna need to sign for it. So I waved the guy away. I'd be rich now. But what I'm trying to understand, because one of the things obviously that we look at is that at the end of this whole process, there are attorneys' fees and all of that's why I'm asking these questions, right? So previously, what if I can ask you in simple terms, what was the attorney's value proposition back then? I mean, we'll get to RAF 1 form. What was the attorney bringing to the table to me as a claimant? The assumption I've had is that I get the claimant, I register them, I give them the form, they do all of these things, I then go to the police station, I go to the hospital, I send someone to run around and do all of this, compile the thing and give it to you. I thought. But please correct me, I really could be wrong.
Well, I guess
Oh, sorry. Let's complete the questions and then we'll take a break. My apologies. Honorable Atkinson and I think Honorable Isaac. Okay, the questions are popping up. Honorable Atkinson, Isaac, Madlala, you had your hand up, Honorable Madlala, and then Honorable Ment.
Thanks very much, Chair, and thanks very much for that explanation. I think you're giving us an example of what would happen in the ideal world, okay? And you still haven't answered my question as to when I asked what is the percentage of successful claims that come directly versus those that go through lawyers, okay? Because I know you've given us the way you can do it directly, but it's my understanding it's still a very difficult process, and that it does appear that people find it very difficult to get a concluded successful settlement going directly. So please can you tell me what percentage of successful claims come directly versus that by lawyers? Thank you.
Chair, honestly, I will need to get those statistics. I don't have them.
That's fine. You can just make a note and then please finish the in writing. It's fine. You can do that. But please just don't forget. Denzel is also making a note. Honorable Isaac.
Great. Good morning. Thank you, Chair, for the opportunity. Morning, colleagues. Chair, a lot has been said in the last 2 hours, and I'm trying to digest all of this. At the same time, I'm trying to educate myself. I would have expected the DM in his opening remarks when he arrived, with due respect to you, sir, is to explain to South Africans and us colleagues, how did we get here? I would have expected you to touch on, how did we get here? Simple. But that's fine, I think. We might understand, but broader South Africans obviously have a different concept and opinion about how we got here. Let that matter be. Chairperson, you raised some very valid and touching points. But when I listen to the gentleman's explanation about how the system unfolds, man, with due respect, sir, but it sounds like a fantastic system. It sounds like it's all working. It's hunky-dory here. Everything is hundreds. That's what I take away from your explanation. I walk in Magogo, from the farm walks in there. We talked of the link number. Chairperson raised it. But then you need my forms, you need my medical claim, this, that. Bring that shortly into. I don't get a link number. Or are you saying to us, without doubt, unquestionably, every claim, walk in, email, there's a link number for that? That's what I need to understand. Because obviously based on the fact that when you one day do address or pay out my claim, you will never pay out that claim without that link number. Am I correct? I think we understand that. So, if I don't have that link number, Mama back there in Maplatsing doesn't have that link number because she's worked via different channels. She doesn't know. And you don't blame her. It's no fault of most of our fellow citizens. 5 years, 6 years, 7 years pass. It ain't happening. So, you say it very clearly in your opening remarks, and I say this with due respect, sir, that every claim that's lodged there, walk-in, email, is immediately given a link number. Is that what you're saying? Because that's what I heard or understood you saying. So I need clarity on that, Chairperson. Then, of course, when it comes to the payment, it's a different issue in terms of percentage, settlements. The lawyer's chairperson alluded to that. The question is, go back 2 steps. This contact center you spoke of, is it so brilliant that it's operating so efficiently? Because if that is all the case thus far, then I say with due respect, through you, Chairperson, DM, we don't have any issues. The Road Accident Fund is performing beautifully. That's my understanding, or I think members of the public sitting out there and watching this on television. Based on what you are saying, we have a good story to tell. But the facts speak a different story. So I'll rest there for now, Chairpersons. I think we've got a long way to go here. Thank you so much.
Honorable Matlala. Thank you, Honorable Isaac.
Thank you, Chair. The first one will be a follow-up from the question I had asked, and I hope that the response this time around will not be academic. The prescribed issue, I just need confirmation that currently there is no claim that is prescribed because you are calling everybody, even beyond the 5 years. I just want it to be understood like that, and also maybe to then understand what then would have informed the waiver of the prescription. To suggest that now we're going to call everyone even beyond the 5 years. Who makes that kind of a decision that we can from time to time decide that we want to go back as far back as 19 whatever if we choose to, and under what circumstances can that decision be made? That's number one. Number two relates to the 60 days from the date of the claim, wherein if a person hands it over physically, if I understood correctly, the 60 days counts from the date that it is stamped and received. However, if it is posted, it will be from the date that it was stamped at the post office. Is that in terms of any act, or it's a standard operating procedure? Because I believe that needs to be corrected, because when you then receive it physically, I believe you also stamp it. Then what is the difference between the traveling times? Why are we not, the one that is posted also starting from the time that we receive it? Because ultimately we don't receive it when it is posted. And with the challenges at the post office, we have no control over how long it takes. But we, however, prejudice the candidates or the clients that actually take that methodology of posting it. Yet we receive all of them, and that can be a common, applicable standard that once we receive it, we then stamp it and we count from that date. Thank you.
Thank you, Honourable Member.
Thank you, Chair. Linked to what Honourable Madlala is asking in terms of the post, can we get a confirmation that we have opened everything that was received throughout the years, including the pile I'm referring to? I don't know, Ntombi will help the chair of which year we were in those offices and which offices. One that is stuck in my mind, which stands out, was Johannesburg, where not a storage, it was even offices full of boxes, not only one office of a storage or something, but there were other offices full of the same boxes of letters to be opened. And there was a citation of lack of staff to open those letters. Now, linked to what informed the calling of everyone on the database, including those that should have been prescribed because of time, is it because you have discovered their responses in those letters, and then it informed you that people actually have submitted, but we have not opened them? Because that might have been the reason. So here there's two. Have you opened everything? Did you actually discover that actually people are submitting, but we are delaying as a RAF to open their post? That's number one. Then number two is at a point of making the, what do you call it? The offer on merit and giving the link number and all of those things. Do you pay immediately? What informs the change of mind? Now here, Chair, when we started this process, it triggered a lot of people to send us information. This I'm going to give you is part of those that were sent. They were even sent to the DM. I requested the DM to give us his office email so that some of the people can send direct to him as well. Here has a link number and everything. I will not read the name of the claimant. I'll give it to you after this meeting. But this was made in 2015. Offer made, it's a person who's claiming for loss of income because the spouse, a surviving spouse and children, on behalf of someone who passed on in an accident. Offer made, link given, everything done. So when it was asked to be an order of the court and the offer was accepted, there was no, it should have been more and whatnot. But then when they asked if it should be an order of the court so that the payment and everything is done, I don't know what informs that. Now RAF started opposing their own offer. And this has been ongoing since 2015. In 2016, it was in court. The court said RAF has no case, struck off roll, they must pay, they must settle. They still didn't settle. When the lawyer goes to East London, this is an Eastern Cape based, when the lawyer goes to East London, now there's a quantum issue that comes back. There's nothing that gets explained to either the lawyer or the victim. But then the matter goes back to court. Since that time, it has been to and from. The court keeps striking it off roll. And then there was even cost. There are all these court rulings on this particular letter. But what stands out in this is that there's different lawyers that RAF keeps sending, and they're paying them to go and fight for something they know for a fact they cannot win. But also, you've made an offer. You're not paying the offer, but now you're dragging the poor woman through courts for this long. I want to understand then what becomes the lawyer's fee, who covers that in this interim? And why is this the case? Why would you make an offer, give a link, and not settle? But even when you go to court, the court rules that you don't have even somewhere here, I'm not reading it because it's 10 pages long with all the court rulings and everything, the judgments. Even your senior attorney, I think that, is SC, that went there, also said we cannot because this is waste of taxpayers' money. We don't have a case as RAF. Let's just agree. But now someone is insisting that let's go and change their offer at court. Let's go and change their offer at court. An offer that was not contested. This is, I think, fifth lawyer now. RAF keeps paying different law firms to represent themselves, which they get defeated at court, but you're still not settling. So at what point do we then do the right thing? I think one of my colleagues said, it looks like it's hunky-dory, this process is working. But this process is not working. It is not working. I'm citing this because it's also in the DM's emails. He's got it. I reminded him at some point that DM, please look on those things. And he cited the difficulties there and all of those things, but he's looking into it. There is 6 more that I did not read, but this one stands out. How does it happen? That's the thing. So who determines the quantum, make an offer, gives a link, and then goes back and say it's all wrong? Who does that? And who in this particular case, I'm very interested, who has assigned these lawyers to go and fight for something that is not going to be a win for RAF? Because we know for a fact it's not going to be a win, but we continue fighting it so that these law firms can get money. This is a double-edged sword. Not that the victim is being dragged, is suffering more than they are suffering. From 2015, it's 10 years later, it's still not being paid. But RAF is doing wastage. There is wastage of money being paid to law firms, briefing, assigning advocates, and all that whole bench of people that go there. There are monies that are attached to them. How much did we lose fighting this? And I can tell you that it's even now more than what we have offered. I don't know what was the offer. It's not cited here. But I'm trying to think that even the offer now is far less than what you are spending fighting a poor victim through a system, because you have a system that you can utilize. It's at your disposal. However, it's not fair. Thank you, Chair.
Thank you very much. Honorable Beasley.
Thanks, Chair. Just in the slide here, it says objection must be made within 60 days from the date of lodgement, failing which a claim will be deemed valid. If you can just expand what you mean by valid. So if somebody's not actually involved in an accident, it's still deemed valid. I mean, what does valid actually mean? And how many claims aren't actually done within the 60 days? I mean, it's a huge risk if it is deemed to be valid. I mean, so if you can just explain what valid, and is there potential liability with that? And then my question, Chair, wasn't answered in terms of when does prescription actually start in terms of the 5-year period that you mentioned earlier. Thank you.
Thank you very much. Last question from me. Was there a time when the direct claims process was suspended, halted at all? So just, was there a time, when was that, and what was the impact, etc.? And then I promise we'll go on break. And DM, you don't need to deal with how did we get here. I'm hoping that you won't, because this is why you have an inquiry. So that question will be answered in that process, but please go ahead.
Oh, thank you, Chair. Respectfully to you, I believe I need to react to that question because I don't know why it was asked. And I do not appreciate the innuendos in which it seeks to bring about. We are here to cooperate with the inquiry. And the second instance is that I apologize to the committee. My office was advised that the meeting starts at 9:30. I was here at 9:30 to find the meeting in motion. Now, it's not incumbent on me then to waltz into this meeting and then take over the agenda. I'm not the chair. If I'm expected to present why we got here, I can give you chapter and verse of why we got here. But I don't think it's going to be constructive that we want to deal with each other in a manner which seeks to pit myself and the public, whereas we have been here on numerous occasions to explain the difficulties that we have and the decisions that we have taken as part of regularizing the RAF ecosystem. RAF is in crisis. We have taken decisions, including but not limited to the dissolving of the board. We've got an interim board. We've appointed departmental representatives. We've got a legislative review underway, precisely because there is a recognition of the material facts before us in the ministry that we've got a crisis. We don't need anybody else to tell us that. And our participation in this inquiry is to uphold the constitutional injunction of accountability and oversight, and we are subjecting ourselves to it. I don't take kindly to the question, Chair, and particularly in the manner in which it is being posed. I'm not here for headlines, and I'm not here to... We are here because there's a crisis. I take a strong exception to that question, a strong one, because I don't think it's asked in good faith. Thank you.
Okay, so colleagues, we are here to establish how we got here, Honorable Isaac. So can I just ask that we, especially in this phase of trying to understand the specifics of how the processes work, try and stick to that if possible, so that we can move on to other people that are going to be explaining to us what we're doing. Again, DMI noted that there was a miscommunication between ourselves, so I have taken no exception to your explanation. Can we get the questions of the members? Can you please just try and not forget, because questions do get left behind.
Before they respond, just in response to the questions that have been broadly asked, I think what we would want to draw the attention of the committee to is that clearly there has been a lapse of public education on the due processes upon which a claim should be carried out. And this will speak to amongst others, the high number of claims which do not meet the requirements or absent documentation. Secondly, what the committee, I hope, will traverse as part of this inquiry is an honest assessment of the manner in which lawyers handle claims. Let me make an example which says there's a matter in my office currently of a claimant whom a decision was taken through lawyers and family that his funds would be placed in a trust. Now, they have got difficulty now accessing that trust. And they have came to us as part of resolving the problem that they have. I would hope that in your witness list there will be a close interrogation of the conduct and behavior of lawyers in this ecosystem. We are saddled with correspondence now which says people have been paid by RAF, but they've not received the funds because the funds have been paid through the lawyers. Those are part of the challenges within the ecosystem. And what we need to do, and what I've asked the interim board to do, is a focus now which says, how do we traverse the public through what a claim process is like and what is expected, and the pros and cons of being represented and unrepresented, because it comes with both come with their own challenges, particularly from an access point of view. So that is one aspect. The second to last point I want to make is, maybe the team will also point this out, the challenge that we have is always less about the merits and demerits of the claim, but more about the quantum that needs to be paid out. That is substantively the issue. So we will always find that there's agreement that the FEMA, there was an injury there and so on. But the dilemma is, and why many of the matters are going to court is, I can always get you more money. That is the challenge. So and this is part of the reasons why we've spoken up with the Department of Justice on the mediation aspect in the court process to try and resolve that particular issue with the matters that are currently in court, because it's now about how much I can get out. And of course, the more I get out, then the more the lawyer can make. And so those are part of the challenges. What is tragic, Chair, is that some of the claimants are unaware that a claim has been rejected, an offer has been rejected. And so they are awaiting a RAF that seeks to say, why haven't you paid me out? Whereas the matter they have, and this is because the law allows that they can make use of a lawyer. We can't prescribe, right? So part of the things we are trying to now untangle with the legislative reform is that particular ecosystem for ease of access. Lastly, Chair, colleagues are very right to point out to the socio-economic inequalities within the ecosystem. As I hear it about public education, about access to lawyers, and so on in healthcare. And one of the major problems within RAF is that, Chair, my leg is most likely more expensive than the leg of Ukoko Udlamini in Ndumeni Etand, for the simple fact that the loss of earnings calculations places me at a higher pedestal. And that is embedded within the inequalities that arise out of this. So this is why you see a mad rush, Chair, of a presence of people who are going to assist you in an injury more in a private hospital than you will find in a public hospital, because already you are at a higher economic bracket just by being there. And so your loss of earnings make more money. And so what we want to do moving forward is a prescribed schedule of benefits within what we are building into the RAPS bill, of course, with the discretion that the schedule of benefits can be reviewed on the basis of economic calculations year on year, so that we sort of equalize the system. There has to be a burden of responsibility, Chair, on myself as an individual to insure my leg if my leg is expensive, and not to turn to RAF as a means of bridging that. So the socio-economic challenges that colleagues raise for me are fundamental, because they are what bring us to this backlog. They are the issue of access there, and then the issue of liabilities that colleagues correctly point out to, and amongst others, Chair, the Concord action which RAF is involved in, and the Auditor General, the directive that remains the position of the ministry since arrival and now, is that the AG must pull out, the RAF must pull out of that action with the AG in court. And we find a responsible way within the accounting standards to deal with the liabilities question. Lastly, Chair, you make an example which I think must not be taken lightly about how somebody approached you to assist you, and you made about somebody being hurt in Mgidin. That is part of the corruption within the RAF ecosystem. I've made the example here how my brother was accosted and being hijacked and beaten up by people, and we rushed him to hospital, and I came outside to somebody said, you should have said it was a car accident. That is part of the corruption embedded within the RAF ecosystem. And so we must not lose sight of the fact that people see RAF as a money-making scheme. And so the stringent claim processes are amongst others, but maybe we can say RAF may have, done a claims process overreach and went above and beyond strengthening its processes. But in part, it's a response to the corruption embedded within how people kick off a claim process. Thank you, Chair.
All right. Thank you very much. Can we just get those answers dealt with in turn, and then we'll go on break?
Chair, thanks. I think I would want to speak to Honorable Mente. I think one of the questions you asked is why would somebody make an offer and then thereafter probably want to deal with it? Potentially because I have not seen the case, and I would want you to give me the case and we'll then give you a written response. We'll investigate what's going on there and provide you a written response. But potentially sometimes people might make offers that they're not supposed to make, and if they are found fundamentally to be problematic in law, then they might have to be dealt with in a court of law. But I am not sure of the specifics of what you have there. Can you indulge us to have a look at it, and then we will put in writing exactly what could have transpired there, because I don't want to make assertions, and I'm not sure what could have been the fundamental fight the RAF is having with that particular claim. But we will chair look at it and respond in writing to the committee and explain what could have transpired in that particular claim. I think I wanted to deal with that. Maybe Mr. Mkhabela, I think there were a few questions around the call center and why did we reach to everybody else and so on. I think Mr. Mkhabela will tackle those.
Through you, thank you, Chair. Firstly, to Mr. Isaac, nothing is hunky-dory at RAF. I think that is a fact. But number two, the establishment of the contact center was an admission that we're dealing with decades-old problems. We have claims which are even more than 10 years old. Now, with us calling all the claimants, it was an attempt to say we're sitting with these claims, which are an indication of our liability. We have to do something about that. That is why we're not discriminatory on who we're calling. But these are some of the dispositions that we picked up. We are not able to reach at least 38% of the claimants, Chair, I must say that. Part of the reason is that they've changed numbers. The service providers, if you don't use the number for more than 6 months, is given to someone else. It's been a struggle for us to reach those claimants. But we did not stop there. We are making use of tracing agents to say, how can we reach you? Because the last number that we had was this number. Up until we have spoken to you, we will not be able to assist you because we don't know if you are even still alive for that matter. So the contact center, yes, was established. It's just under 2 years. We have had more than 1 million interactions through that platform. But we are now in a better position to understand who's calling us and why are they calling us. In the past, Chair, we had a very small contact center manned by very few warm bodies. We could not even tell if we're dealing with repeat calls, let alone the total number of queries we're dealing with. Where we are right now, we know exactly who we're dealing with, direct vis-a-vis the plaintiff attorneys. We also understand why some of the claims are not moving because of the issue of the outstanding documents. So through the contact center, we'll call and say, Mr. Isaac, we are still awaiting a medical report, which your attorney hasn't finished out yet. It will be impossible for us to progress further than that. But we do have instances where the reports were submitted, but the whole claim had to be investigated because of suspicion of other, corrupt practices that the DM also alluded to. So it's a function of many variables, but to your point, we are reaching more of our claimants than we ever did in the history of the fund. We are also, as I've indicated earlier on, digitally reaching out to our claimants through WhatsApp, through SMS, through SSD. So the mode of communication has improved to the point where we can, comfortably say that we have a better idea of where the backlog is and how to eliminate that. So I wanted just to make that point, but I'll be covering that when I talk to the queries management, because that's why we go into details in terms of what channel are we using and what are we getting out of it. to make sure that we also use that as an opportunity to educate the public about the claims process in its entirety. Thank you, Chair.
Chair, if I can comment on some of the questions that has been raised. For Honourable Member Madlala, he had asked the question about the 60 days to object, the date stamp. How are we using it, or why did we use that date, the stamp of the post office? It is in the standard operating procedure that governs us on which date we need to use in respect of the lodgement date. So that would cover your question. To answer Honourable Beasley with regards to the 60 days and whether it deems the matter valid in law. So what would happen is, if we do not object to the claim within 60 days, the claim will be deemed valid in terms of that substantial compliance has been met and a valid claim has been lodged. It does not determine liability. That is still something that gets determined at our merits, in our merits department. We are a fault-based system, and therefore, firstly, fault needs to be determined before we move on to investigate the quantum of a claim. A question was regarding the post. So, Madam Mente Nkuna, what would happen is that on a weekly basis, we've got a document management department where part of the duties and responsibilities are to collect post at the post office. Over the past few years, there has been a decline in how we receive our mail from the post office, and it is something that has been articulated and ventilated in a number of meetings that we've had with regards to the opening of, well, collection of correspondence, and then as well as opening of the documents. This occurs in document management services. All regions, they are supposed to have opened all documents that has coming through the post. In terms of boxes, I cannot confirm whether or not it is...
Sorry, can you just explain this thing around the post office?
So...
What has been the challenge there?
So what would happen, and I can speak for Eastern Cape, between the various post offices, if someone in Kabeja sends documents, lodgements via registered mail, it does not get there within a reasonable period of time. So we find that sometimes it can take up to a month or two for documentation to actually reach the post office East London. So this does occur. Yes. And then just the last question on prescription. So what would happen is that the date of accident is the most important date because the cause of action arises on date of accident. Within a period of 3 years, that is in which time a claim needs to be lodged at the Road Accident Fund. After the date of lodgement, there is the 60 days in which to object, and an attorney can issue summons anytime after day 120 if a claim has been registered with the Road Accident Fund. If the RAF objects or we repudiate the claim before the 120 days, that attorney has a right to also issue summons. The 5-year period of prescription runs 5 years from date of accident to the date before which the claim prescribes. So that is the prescriptive periods in respect of the claim. Thank you.
Okay, so this is very important, just to be clear. So the prescription clock, therefore, begins on the day of the accident. Okay. I just, please, I mean,
It's 2 sets of prescriptions.
Okay, so just...
They need to unpack.
Yeah, please just unpack that. The committee members need to really understand, because earlier we spoke about, the thing arriving and being stamped and so on. So please help us untangle that thing.
Okay, thank you, Chair. So firstly, from the date of accident, you have either a period of 2 years if it is a hit-and-run accident, or 3 years if it is unidentified motor vehicle involved in the accident where either the driver or the motor vehicle has been identified in which to lodge that claim. So that is the first prescriptive period. If a claim is not registered or lodged within that time period, they cannot claim, or the victim cannot claim against the Road Accident Fund. If a valid claim has been lodged within the specified time period, which is 2 years or 3 years, they are then able, the claim needs to be processed within a period of up to 5 years. So a claim can be registered 2 months from date of accident if all the necessary documentation has been obtained for a claim to be registered.
I'm with you. So in other words, can be anything from basically up to 7 years, basically, or thereabouts, depending on when the accident happened and when the thing. So I could lodge a claim on month 23 of that 2-year period for a hit and run. There is then another, how many years before it? 3 years, right? Okay, no, I get you. So there are 2 prescriptions. There is a deadline for you to submit a claim. Then there is a deadline for when the RAF is expected to pay. If nothing happens in that period, sorry for you, you came too late. That sort of thing. So there are 2. Okay, thank you very much. I get it. But please continue.
But Chair, I think the point you make of sorry for you, normally then it's like we say in the presentation, then it's interrupted by a summon. Okay.
Sorry, there were other questions. So for instance, I did ask about the direct claims process. Was it ever, let me put it to you this way. I'm trying to get at this, okay? So in your story that you've told, and I don't mean story in a bad way, basically how you've narrated the issues, right? It appears that a decision was taken to reach out, as Mr. Mkabela has said, to reach out to people going back quite a long time so that you can basically work through all of the claims. Something must have kicked it off. You know what I mean? Because you've just been explaining what prescribes when and that sort of thing. So it would appear, into Honorable Madlala's question, that you've taken a conscious decision was it from March this year? Whenever that project began, right? Whatever, you'll give the date. You've taken a conscious decision to reach out to people going past all of these prescription periods that you're talking about. Or is that not so? I also am asking because during the course of the submissions that we got, we also understand that there was a directive to halt the direct claims process, right? For a number of years, which would have then created, I am assuming, a backlog of cases that are waiting because, well, it's halted. Other people now don't know what to do, and I'm assuming they then go to attorneys, whatever the case is. So that's why I asked the question. I just want to know what triggered the decision to try and clear a backlog going back years.
So Chair, I think
There are 2 questions, by the way.
Yeah.
What triggered that decision? The second is a very direct question. Is it true that the direct claims process was ever halted or suspended, and how long was it for?
So the trigger, Chair, of looking for documents, and probably one would then want to marry this when we speak to the RAF 1 form. So you ordinarily would have claims in the RAF that were submitted on time, and then after they were submitted, so let's talk about represented claims, they would have been interrupted by the prescription by someone, and then it stays there. And there's a lot of claims that people will bring documents and they'll try to settle. We must mention that because it happens. It must not be the fact that we're saying that people don't bring documents, but there are people that will bring documents and ask for settlements to be done. But there's a chunk of claims that are sitting where a form was submitted and nothing was submitted to the RAF to substantiate the ability of the fund to assess and make an offer on that claim. Now, the reach out process to say, and I remember one of the campaigns, I think it was named Bring Your Documents to the RAF, was essentially was saying, we've got this much backlog, we want to get rid of the backlog. And when you do an assessment to try and get rid of the backlog, you realize that if I want to settle this claim, actually I have an example, Chair, where we actually wrote letters to, I think, to the point of honorable ment around loss of support. You know, when you deal with a loss of support, it's because somebody has passed on, and therefore you want to deal with those claims quicker, or at least if you can. And there was a project that was run to try and address loss of support claims. And letters, specific letters were written to particular attorneys to say, you've got this claim within the RAF, and we identified it as a loss of support. We want to settle this claim. These are the documents that are missing for this claim. This thing has been sitting in the system for quite a while. Can you give us these documents that we can make you an offer? In my recollection, Chair, there was less, or rather the responses were not as we thought, because we thought people would jump to their opportunity to bring documents. So the trigger is to deal with the backlog, and I must just say, is to say there are so many claims that are sitting in the ecosystem. I mean, some of them go far backwards, Chair, and I must say, way back. And the trigger was to say, we need to get these things out of the system. So we need to then, you need to make a test to say, did this claim prescribe? Because if the claim is prescribed, there's particular process that must be dealt with to make sure that the claim that is not in the system anymore. Is the claim settleable even though it's old in the system, it has not prescribed? Are we able to settle it? And this is when the call center then reached to people to say, give us the documents, because your claim has been in the system for quite a while and we want to settle that claim. So essentially that campaign, Chair, was based on the fact that we are dealing with the backlog. And I think going forward, we are looking at a project that seeks to get rid of the backlog so that we get rid of the old claims that are sitting in the system. So essentially that's what, and these exercises, Chair, are also not done only at the call center, but various regional offices would be reaching out to try and get claims settled. And to settle a claim, you need particular documents of claims that would have been sitting in the system for quite a while. So that's the trigger that caused that.
The direct claims process.
Chair, I don't recall and I'm not saying it's not existing, I honestly don't recall a directive that stopped the direct claims. But I must say that when we deal with the RAF one, we'll show the impact of the RAF one form, like you had asked in the question, that we must show that impact. But I don't recall it. If it's there, Chair, I don't recall it, where there was a directive to say the direct claims process must be stopped. And again, I will check with my colleagues or check if there was a directive like that. And if it's there, Chair, I'll come back and consider and say that directive was there.
Okay, so something happened between 2019 and 2022. There was a period when things couldn't be processed. So the reason I keep circling this issue of the backlog together with this question is that in my mind, they are not unrelated, right? And we need to then know for the Secretariat what further questions to ask, because we invited submissions. We got a fairly substantive, at least a clear submission that from 2019, I'm looking at it, so from 2019 October until 2022 December, what happened in that period? The person might have misconceived it, what it is. Can you explain what that issue was?
Thanks, Chair. What I recall was that sometime in 2020, I think around about December, if I'm not mistaken, there was a decision to say that RAF must process all the direct claims. And that decision, I think it was taken just before the introduction of the RAF 1. The objective, I think, of that decision was to say that we've got all of these claims that are sitting on the system which are not being settled and they lack documentation. Now we want to introduce a new form that says that when you bring in your documents, you need to make sure that then you've got all the required documents so that then we can be able to process that claim. So the one that I recall, I think it was that decision. As a result, I think there was a project that was established to make sure that then it deals with the settlement of those direct claims. I was working with that particular project.
Right. No, I mean, we'll work through it at another time, right? But it would appear that there was some change in procedure. It halted the processing of direct claims for a period. And then, that's why I'm linking these two. But we can deal with that at a later stage, maybe when we've dealt with RAF 1 form. What I need to ask is, you said, Mr. Mkabel, that you used to have a tiny call center. When was that, and how many people did it have at the time?
Thank you, Chair. We established the current contact center, Chair, under 2 years ago. On the 9th of October 2023, that was the beginning of the current contact center as we have it. Prior to that, for many, many years, RAF has always had a call center department, which was not fully resourced to deal with the vast number of claims that we're dealing with today. It was out of that realization that we needed to change that part. But also, one of our outcomes is to ensure that we are claimant focused.
No, don't worry.
Yes.
I just want to know the raw facts. I mean, this is not a trick question at all. I just want to get my notes. So there was a call center before. Can you approximate the number of people that it had?
I would say about 34 agents in that contact center, yes.
So there was one call center nationally,
yes,
with about 34 agents.
Approximately, yes.
Yes, and then you looked at your operational environment and you decided to expand it. To how many?
Okay, we realized that we needed to beef up the capacity for us to address, amongst others, the issue of backlog, etc. Because we also realized that our claims handlers were bogged down with a lot of queries, instead of them focusing on the core business of assisting to settle those claims. We then participated in a contract driven through the Department of Labor.
That detail, okay. I'm sure, please, I'm not going anywhere with this. We can maybe deal with that at another time. Okay. I just need to know that you used to have 34.
Yes.
Now you have approximately how many?
As we speak, for 300 agents.
Right. Okay. So you basically nearly threefold.
Yes.
Yeah. Well, more than that, yes. Actually. Yeah. Okay. So, but you've really vastly improved your capacity to process calls. So when did you basically expand that capacity? Again, it's an approximation. It doesn't have to be a specific date.
I'll say around September of 2023.
Okay, around September of 2023 is that's when you.
That's correct.
You started doing that. Okay, no, I really wasn't. I know we asked for detail,
yes,
but sometimes the detail is not necessary. So I get where you're coming from. I just want to be certain before we go on break. Is there a question that has not been answered?
Yeah, sorry, I don't mean to keep on banging on about the same thing, but it is about that percentage that I asked about. I know that they said that they're going to get the information, but can we get a time frame, please? Because I don't want this just to kind of disappear into the ether, basically.
No, it won't, because we need to deal with it during the period of inquiry. So Denzel made a point to remind to remind them. So the time is. I'm really worried about you, colleagues, because unlike the members, you're not able to step in and out. So can we please take a human rights break so that our colleagues from the RAF can also walk about and stretch their legs? It's 2:15, so can we come back here at 12:05, please? Thanks.